Welcome students to this lecture on economic, social and cultural rights. Before we begin, I want to make two sources of information available to you. The first is the Holodomor, for which I've only read it through Wikipedia, and the second one is the book Late Victorian Holocausts. Both of these topics deal with famine. And famine, the reason I want to stress famine here now at the outset is because to get a grip, to get a sense of how social rights are human rights, to get a sense of the significance of social rights, I think we need to encounter, let's say, their complete inversion or their complete negation. And just as for the civil rights, you can find their complete negation, for example, in the Nazi concentration camps or in the Soviet Gulag, for social rights, we also have to see their complete negation in famines such as the Ukrainian famines or the famines of the 19th century. So, my own experience, maybe my limited education, made me familiar with the former but not with the latter. So, even while I was writing my thesis on social rights, I knew about Nazi Germany and I knew about, well, I guess I knew a little about the USSR, but I knew virtually nothing about the famines of the 19th century or the famine in the Ukraine. And it's shameful that I didn't know more about it. It's amazing that I didn't know more about it. It's amazing that I went through so many years of education and I never even registered that something of this dimension, of this human dimension, could have ever happened. So, just as a bit of a recommendation, and don't do this at night because it will keep you awake. Do read about this. Do know about this because it will tell us a lot about the reality of the world in which you live in, and it serves as context for social rights as human rights. So, yeah, give that a look. The book Late Victorian Holocaust is one that I strongly recommend. So, I've had the benefit of reading that book, and it changed my outlook on many things. So, give that a look, and now we proceed directly to substance. So, what are economic, social, and cultural rights? Well, quite simply, these are rights that protect you from state abandonment or from social abandonment, whereas civil and political rights protect you from state abuse. So, they protect you from the state being violent to you, torturing you, murdering you, censoring you, and so forth. Social rights protect you from abandonment from the state and from society. So that means, for example, that you are left to die without healthcare, that you are left to starve without food, that you are left without water and get sick thereafter, or that you are never provided education and thus your human capabilities are never realized. So these are what ESC writes, and by describing in this manner, I can say that pretty much all ESC rights connect to the problem of poverty. So to the problem of poverty, which was characterized by FDR as want, and then social rights would become the opposite of that. They will become freedoms from want, protections from want and from poverty. So they convert, let's say, the liberal democratic order of human rights into a social liberal democratic order. That is the idea behind economic, social, and cultural rights. Let's say some brief remarks about the history of social rights. First, let's say that social rights are newer. Civil and political rights really already entered the stage in their legal incarnations after the French Revolution and after the American Revolution, so the American Bill of Rights, and then already by let's say the 19th century, there was some history of judicial protection, of judicial engagement with these rights. Social rights are much newer, and they entered the stage much later in the game. So they are essentially in their modern history, they go back to the thought of FDR. So Franklin Roosevelt wanted to promote a vision of social democracy both nationally and internationally. Nationally, that was through the New Deal. internationally, Roosevelt made sure that in the vision of human rights that was getting developed in the international sphere, freedom from want, so social rights would also be part of the package. Then in the Universal Declaration of Human Rights that was written in 1948, we do find joined together in the same document the classic civil rights, protection of life from torture, speech, religion, and so forth. And we also find the new social rights, food, housing, education, and so forth. And the idea that is that after the war, where so many human sacrifices were asked, let's say, to the middle and low classes, the classes that provide the soldiers, then there was a need for a new social contract, one that would put welfare of the population in the table as a significant concern. So social rights expressed the hopes and aspirations of that era. However, they proved polemical. When it was time in the 50s to move from the Universal Declaration of Human Rights to something like a Universal Treaty on Human Rights or a Universal Covenant on Human Rights, this is when the problems got started for social rights. So the idea that social rights would be part of the package started to become unacceptable to many countries. Countries in the first world regarded social rights as not really rights. So what is a right? A right is protect me from state abuse. Then something like welfare, that is either something that's a public policy issue or something that is a matter of charity, but certainly not a human right. And then the countries of the first world technically opposed the creation of social rights into a binding instrument. At any rate, they didn't want to sign an international human rights covenant with them in it. By contrast, then you would expect, say, the USSR to take the opposite picture, and but that's only partially true. The reality is that the USSR did not want human rights of any sort, except merely for decorative purposes. It fell to the third world to defend the idea that human rights had to be both civil and social. From the debates of this era, I remember very much the intervention of the Chilean delegate. This was Chile before just few months or few years before the Pinochet coup, and he was saying for us Chileans in the third world, no, we're living in third world democracies. No, we have freedom of speech, we have freedom of religion, but the problem is that we cannot use them, that they are worthless to us, because poverty is so crushing that we cannot take advantage of all these freedoms that we have. So then it really ended up being the third world that really defended the idea of social rights needing to be rights. However, because they were polemical, it was necessary to break down the two international treaties, to break down the, let's say, the projected Universal Human Rights Treaty into two, the ones that that we have right now, the ICCPR and the ISESCAR, and that's how it came to be that we have two human rights treaties instead of one at that very fundamental level. Even though even though the treaties were split up. Now, that was not the only thing that happened to ESC rights in this history that treated them as second rate. Now, when this ISESCAR was drafted and planned, it ended up being weaker than the ICCPR. So if you judge human rights treaties how strongly or how weakly worded they are, the ISESCAR clearly is the weakest one. So if you see the provisions, there's many ways in which the ISESCAR was written in a way that is softer in terms of ambition and in terms of monitoring than the other human rights treaties. The main issue, of course, is Article 2.1 of the ISESCAR. Article 2.1 of the ISESCAR states that the rights contained in this document are to be achieved only progressively, taking into account the available resources of the country, using international assistance and cooperation, and instead of saying simply that the state must guarantee and protect these rights. That is to say, social rights appear as qualified rights. So instead of saying that no, the state has to provide health, has to provide housing, has to provide education, Article 2, Paragraph 1 says that the state needs to take steps to progressively taking into account the resources it has available, it has to take steps to try eventually to achieve these rights. So here we have what essentially is a very qualified obligation. And at some point you would say it's so qualified that maybe it's not an obligation at all. Maybe it's just something desirable, a goal, a nice thing, but it's not really a right, not really an obligation, that it does not have the sharp edges where you can say there is a violation. For example, let's imagine you meet a person that is in the street homeless and ill because he has not received medical treatment for a condition in months. And then you say, well, is this a human rights violation? If you go back to Article 2, Paragraph 1, the answer would be, I'm not sure. Because I am not sure if generally, the state is still progressing towards eliminating homelessness, whether the state is still progressing to provide medical care, and whether the fact that this person is homeless and ill is not reflection of the fact that the state does not have any more resources to spend on that topic. So the obligations are extremely qualified. And of course, we will say a little bit later that this is something that also makes sense, because you cannot say that the state can eradicate poverty overnight, or that a poor country can provide first class treatment to diseases like cancer or HIV, which require extremely advanced medical technology. But on the other hand, it also makes it very difficult for us to say that something is a human rights violation, because the demands are qualified in an extreme degree. Less significant but still worth mentioning, whereas in most human rights, let's say all except one of the human rights treaties of the UN, created an independent body of experts to supervise compliance with the treaty. For the ISESCAR, this task was delegated to ECOSOC, because they say, well, these rights, a little bit what's behind this, if they're saying that these rights are not really rights, they're just more political objectives, and as political objectives, they're not fit for expert supervision, they're fit for political supervision, and hence the task was delegated to ECOSOC. As you know from my other lecture, this proved to be unworkable, and in the 80s, ECOSOC already created a expert body to deal with the rights, just like all the other expert bodies. But still, you get the idea that the rights were conceived to be weaker and less enforceable than the other rights. Something else that we can mention here is that complaint procedures, the idea that an individual could say, well, me as an individual, my rights are violated, I'm going to Geneva to petition for a opinion, for a view leading to identifying that my rights are violated and asking for compensation. Well, in the ISASCAR, you didn't have that. You didn't have that until the 2000s. It took decades for the United Nations to accept the idea that individual communications for these rights could be possible and could be useful. And of course, that has a lot to do with the weakness of Article 2, Paragraph 1. Because remember, if I say, well, I have not have access to education, I have not had breakfast today. If you think about stuff like that and you look at Article 2, Paragraph 1 and you ask yourself, is this a violation? The most immediate answer you will have is, I don't know, because it all depends on how fast the state is progressing. It all depends on the available resources. Essentially, the human suffering that you see in an instant case becomes relativized in terms of macroeconomic indicators because of the weakness of Article 2, Paragraph 1. Now, let's say something about why these rights are regarded as polemic, because there's two halves of the story. First, there's one that is political and ideological, and there's another one that's technical. So the political and ideological part of the problem resides with economic liberalism. Economic liberalism is beholden to the thesis that in order to achieve development, what you have to do is essentially protect civil liberties and then leave people alone. That by their selfish self-interest, that by let's say their selfish interest, people trying to achieve wealth, having ruled out the possibility of violence, threat, and deceit, what they will do is engage in mutually beneficial cooperative activities, that this will generate wealth, and that this will eventually, resolve all the social problems of society, resolve the economic problems of society as society gets wealthier. So there's many versions of this, going back to Mandeville's fable of the bees, where let's say greed becomes, let's say private buys like greed becomes a public benefit. It's also connected, of course, most famously than anything else, with Adam Smith's idea of the invisible hand. But you see this idea coming up again and again in economic liberalism, that essentially the way to achieve economic prosperity is by keeping the state out of the economy. Now, the economy then is something like an independent sphere, a sphere that has its own logic and that should not be intervened upon, and that if it's intervened upon, you will only have negative effects. Now, this idea, which is it's a very important one. It's not one that we can simply say it's wrong, because there's a lot of work and a lot of evidence to it, and there's also a lot of work and a lot of evidence against it. Now, what is the fact of the matter is that this idea has been behind the hostility to economic, social, and cultural rights, because economic, social, and cultural rights do project that state action in the field of the economy is necessary in order to ensure these basic human rights, that these basic human rights cannot be left to the operation of the market and private charity. And many would think that, creating this sort of demand would spoil the formula of economic liberalism. So countries that are attached to a strong version of economic liberalism will naturally feel threatened by the idea that economic, social, and cultural rights should be part of the fundamental rights package. So that is for starters. So that's, let's say, the ideological part. And there was some signaling also, right, in terms of affiliation to the Western Bloc or to the USSR bloc in relation to social rights. If a country wanted to say, "I am really a friend of the Western Bloc," they would shun social rights. If they wanted to say, "I am a friend of the Eastern Bloc," they would sign up and celebrate social rights. And of course, third world countries would say, we are neither one or the other. We ratify both. We care about both. And that's how, it's a very interesting story about how the third world became conscious of being in the third world and started to act internationally as such. And this is one place where that happened. But there was also this sort of signaling game of rejecting these rights in order to show that you are part of the first world bloc, or let's say accepting them to be part of the second world, third world, first world, second world was the USSR, and to be part of the second world. So there was also this sort of political signaling game, which, let's say that on part of the Soviet countries, this was of course purely symbolic, because Soviet countries were actually not attached to any form of human rights whatsoever. They operated on different principles. But besides these political reasons for creating polemic around social rights, there were also technical reasons. And I will stress, let's say, the two more common ones, and I will give you a third one, which I think is actually the most crucial one. Okay, so the two main technical reasons have to do with the competency of judges and the polemicity of spending decisions. So is a judge really competent to say whether money spent in a certain manner should be better spent in another manner? So if you say, well, here's a case, and the case says that this person that has a severe renal condition. However, we cannot give him dialysis because the funds are spent elsewhere, for example, in research on the diseases of children. Can the judge really choose? Does he have the competence, the technical expertise to say that no, the money should be shifted from some other expenditure to protecting renal diseases? And that can be, research in children diseases, but it can be anything else: construction of a dam, construction of roads, spending on schooling. So these spending decisions seem to require a technical expertise that presumably a judge would not have. That's one issue. The second issue is that relating to spending decisions, these should be decisions made by the legislature, decisions made by the body politic, and not decisions made by a judge. So it depends on the decision of the country whether they want to emphasize health, whether they want to emphasize education, or if they want to sacrifice some degree of welfare in the present to have more welfare in the future. So these sorts of decisions are essentially political economic decisions, and then it's not possible to say that a judge can take them. So a judge cannot say, well, do we have the Kerala model or do we have the, let's say, the Hong Kong model? Which model of development are we going to use? Are we going to be a little bit more like Chile, or are we going to be a little bit more by Peru? Well, there's a trade-off here. Chile has a much better welfare system, but Peru has higher growth rates. So these sorts of decisions, you could say, macroeconomic decisions, we want to keep them away from judges because first, judges are not competent about them, but second, and this is more also dramatic, these decisions affect everyone and they should be taken by a democracy. But there is a third problem that I consider to be the most serious problem, and that was the focus of my doctoral thesis, which is essentially the problem of equality in a context of scarcity. So here's the issue. Human rights are granted to everyone. If you say that this is a human right, it means that it's a right for me, for you, for the old, for the children, essentially for everyone. That is, human rights are universal. But social rights are tied up to a scarce resource pool. So at some point, your ability to provide dialysis treatment ends. At some point, your ability to fund school meals ends. At some point, your ability to hire experts to provide education for the mentally disabled ends. At some point, your ability to build more social housing ends. And then what happens when you have a petitioner claiming that his social rights must be honored? If you honor that petitioner and you make good at his claims, well, then if you see the instant case, that looks very positive. No, that's what we're seeing. The person comes here with a problem, he comes here in a state of social exclusion and abandonment, and the judges make a progressive order granting him healthcare, granting him a house, granting him whatever he petitions that he needs. But that's where the spotlight is. But then what happens in the shadows? What happens in the shadows is that the attention that you give him comes from a resource pool, and that resource pool naturally will be diminished. So you attend the claims of housing of this person, the claim to let's say a vaccination plan of that person, or the claim to expensive medical treatment of that person, that reduces the funds available for the claims of other persons. And then you say, well, in this way, the equality of social rights ends up being inequality. It ends up being, let's say, that the quality of dignity gets really honored to those that litigate, but those that do not litigate or that will want to litigate later are simply not attended to. They're not protected. They're not given attention. And then we can celebrate all that we want, the good outcome that happens in the individual case, but we must think that we must be able to provide an answer then for those that come later, for those that are not able to litigate, or for those that litigate at the date when their resources are already over. What can we say to them about their claims? And essentially the problem here is, how do you make social rights adjudication egalitarian? If you simply attend to the person that comes to you and just protect that person, uh, fully give anything that the person asks, there's a threat that you're actually being generous but inegalitarian, because you are depleting a resource pool that other people need. And one way to put it, let me put this in a graphical sense. Some authors have called this the problem of sharp elbows, and some other authors have also called the problem of queue jumping. So there's many people that need expensive medical treatment. One of you is able to litigate, and therefore he has very sharp elbows, so he gets first in line. Or you could also say he jumps the queue and gets attended first. But then it's more waiting time and potentially denial of treatment for others that were not able to litigate. And then does that really make sense? Is that really the egalitarian or the human rights conscious way to proceed? So essentially, when you're dealing with social rights, you're dealing with the problem of scarcity. And if you want to have interventions in this field, you would have to make them in such a way that this problem is addressed. Now, the difficulties noted in relation to social rights are difficulties, but they're not impossibilities. And what's been interesting is how courts have managed to find workarounds, or in another way, just defeat these considerations and provide protections in issues of social rights. And I will tell you immediately that to tell this story, we must move from international and UN to local. And specifically, we must go to the South. We must go to countries in the South which have been the ones that have been creative in providing protection to social rights. Not without exceptions, there's some interesting judgments, for example, in Germany, but for the most part, the action has been in a few countries in the South, like South Africa, India, Colombia, Argentina, that have been creative and or aggressive in protecting social rights and either circumventing or just outright defeating the fears and the worries that that were presented just a few minutes ago. So let's just start with South African reasonableness review. So South Africa has been it's the most well-known jurisdiction for protecting social rights. South Africa is also the jurisdiction that has been the most technical about it, the one that has really wrestled with the technical problems that were discussed beforehand. So the issues of democracy, of judicial competency, the problem of sharp elbows, of queue jumping. In South Africa, you see that something like a judicial workaround for that. And the name of this workaround is reasonableness review. And reasonableness review, essentially what it does is says, okay, you have a right to housing, but for reasons that were explained, that cannot translate directly to you getting a house. What that can translate to is to the court reviewing the social housing programs from a human rights perspective to improve them, to change them, to make them more human rights responsive, without, however, the judge being able to say that this person gets a house tomorrow. So if you see that, you essentially will see that the problem of sharp elbows or the problem of queue jumping gets avoided because the court does not give a direct entitlement to the person. Rather, the court just gives orders to the state to modify its programs in a way to make them more human rights compliant. But the ordering, let's say the triage or the ordering of social provision, remains governed by the principles and the expertise of the executive branch. And what sorts of principles are we thinking of? So essentially, you could think about this in two ways. So first, there's guidance at the level of principle, and this is something that you see, for example, in the Grootboom case. The Grootboom case related to, let's say, I will simplify to a very large extreme, to a significant amount of people that were homeless and were living in desperate conditions. They petitioned to the court in terms of the right to housing. There was a housing plan by the state, and then the court said that it understood the difficulties of the state in providing housing, and it understood that there was a housing plan in order, but then, according to the petitioner's claims, it revised the housing plan and noted that the housing plan had no provision for those that were vulnerable and instead in a situation of urgent need. And then the court, instead of saying, okay, this person has a house, this person gets a house, what the court did is ask the state to reform its housing program to make it more human rights conscious, and then to have a provision for those that are in an urgent situation, in a desperate situation. Indirectly, it is hoped that this would improve the situation of some of the homeless people in the Grootboom case in a speedier manner, but the court was not able to say, okay, this particular homeless person or this particular desperate situation. Now the state must give you some shelter. What the court simply did was reform the housing program in such a way to make it more probable, more likely, and speedier for persons that are in a situation of desperate need. And a second thing that the court can do is simply address administrative irrationality. So the court says administrative action must be reasonable. So essentially, that's a way of saying that the court will not say exactly what you must do as a state. That is your discretion, and that's a discretion that's founded on your democratic legitimation, and it's a discretion that's founded on your institutional competence. But if the state is behaving in a completely irrational manner, if the state is behaving in a completely unreasonable manner, then the court will intervene, not to tell the state what it needs to do exactly, but to strike down the aspects of its policy that are completely unreasonable. And then there's the case of the treatment action campaign. So this treatment action campaign then dealt with the HIV epidemic in South Africa. There was a drug called nevirapine. Nevirapine would prevent transmission of HIV from mother to child, so it protected children so that they could be born without HIV. And then what happened is that for many reasons, some of them even relating to scientific prejudices, in spite of the fact that the drug was free from South Africa, so South Africa had gotten nevirapine for free, the government was not distributing the drug widely. The government was only distributing the drug in two sites, in two experimental sites, instead of distributing across the country. So an NGO called Treatment Action Campaign said that this was completely unreasonable, and it was. The court found that it was, so that was based on some sort of a strange prejudice. And of course, there will be safety concerns in using a new drug, that's understandable. But what was at stake in a situation like this, where essentially children would be born with a death sentence, was so much that any safety concern or any step-by-step approach or precautionary approach on the part of the state in expanding coverage of the drug was absolutely irrational. So the state needed to make the drug widely available to everyone. So that was the only adequate, the only proper response. So essentially, this was an assessment of the proportionality of the state measures. The state was taking measures that were completely disproportionate to the task at hand. But note again that the judgment does not say that this particular person gets this particular social benefit. It's a judgment that is very indirect. It's a judgment that simply assesses the state policy, the state planning. One way to think about social rights in the South African scenario, so how South Africa managed to make social rights effective and overcome the problems of sharp elbows, queue jumping, and democratic legitimation and uh, institutional competencies, is to use a terminology from Amartya Sen. So Amartya Sen, in an article on the right to food written in the 80s, comes up with the idea of a meta right. So where you have rights, and rights are, let's say, demands for some concrete things, for a certain concrete liberty, for a certain concrete prohibition that I'm not tortured, or a certain concrete prohibition, maybe that I am given food or shelter or housing. Except social rights would be best understood as meta rights. So not rights of you individually for this concrete social provision, but rights to have an institutional environment that is conductive, that you get certain benefits. So it's not a right that I immediately get a housing, or a right that I immediately get a medicine, but right for an institutional environment that is conductive for me to getting housing, and that is conductive for me to getting medicines. So this idea of set of meta rights, the word meta rights of course does not appear in the South African jurisprudence, but it's an excellent way to understand what's going on there. So the court is transforming this right from an individual claim, is transforming it to an institutional claim, a claim to reform policies and programs in such a way that they are more likely to achieve their objectives in a human rights manner. So that's for South Africa. And the contrast from South Africa has to be India. Now, India is a jurisdiction that is not well known, and it's not well known because its jurisprudence tends to be very intricate. Its cases sometimes are very long. So there are Indian cases that are 600 pages in length, and then it's very difficult for one that is not versed with Indian jurisprudence, one that is an outsider looking in, to really grasp the whole of what's going on in India. But India has actually been in the field of social rights. It has actually it's notable for two things. So first, it's actually the first country that developed the strong social rights jurisprudence. Where South Africa started to deal with social rights in the 90s, India was already dealing with social rights in the 80s. And India is also the most aggressive jurisdiction in relation to social rights. So in India, whereas in South Africa, social rights become some sort of meta rights, and the court makes a very scientific decision of not giving the individual relief but rather modifying policies. In India, actually, the individual gets relief. Not all the time, but in extreme cases that happens. And then you would find cases, for example, and of course also you have to mention Indian public interest litigation, where essentially what happens is that the court does not even have to wait for some claimant to bring the case before the court. Now, there's been cases in which the court simply reads a newspaper, looks at something that happens in the newspaper that reveals a tremendous human rights violation, and they say motu proprio, so by my own will, they take up the case and give a judicial order. So you would have in India a case, for example, of a woman giving birth in the side path, and giving birth in the sidewalk, and then dying shortly thereafter. And the court becomes cognizant of this through a newspaper, and the court simply immediately orders the state to create a medical provision for women that are indigent and that are pregnant, so that they would not have to give birth in the sidewalk and die. And then you see the courts in India, when they do this, they very often do not even mention concerns of separation of powers, of democratic legitimacy, of queue jumping. And they simply do not mention this. And it's interesting that in spite of having done this, in more than one occasion, so for example, simply saying, okay, children need meals in school to perform correctly, there's hunger in the province, state, you simply have to provide school meals. You simply have to. I'm sorry, I don't care about your budget. You have to provide school meals. There must be food. Don't tell me there's no food. There must be food. Go find it. So that's been the attitude of the Indian Supreme Court. And what's interesting about it is that it has actually not undermined the legitimacy of the Indian Supreme Court, but on the contrary, it has raised it. So if you say, well, the court is acting against separation of powers, the court is acting against democracy, surely people will be angry at this. No, on the contrary, the Indian Supreme Court is actually the most legitimated institution of the country. And something similar has happened in Colombia, which also has been very aggressive in requiring the state to provide, for example, medical care for children, or to provide prisoners with better cells, so prisoners that are in conditions, inhumane conditions, let's say 8 prisoners in a small cell. And then these have been very aggressive measures, and the courts have not been legitimized for them, but on the contrary, have been considered to be, let's say, the most brilliant part of the government system, or the only part of the government system that gets any sort of respect. Now, and then what's going on here? Uh, I like to call this a scenario's leadership. What happens here is that the Indian Supreme Court or the Colombian Supreme Court takes a leadership position, and in a case takes a decision of principle and addresses that case. And then the idea is then what happens to the democracy and the separation of powers? What happens to all the other considerations? Well, one thing to say about this is that, you know what? The court steps in because the democracy is malfunctioning. The court steps in because the system of governance is malfunctioning. So don't tell me about queue jumping because the queue is not working. Don't tell me about sharp elbows because people are simply dying. There's no queue. There's no things are not working out as per system. So if the court disrupts the system, well, there's no system to disrupt. And then what happens here is that aggressive action, leadership action from the courts, although it's not normal and it's not desirable in an ideal world, if you are in a sub-ideal world, it becomes viable, it becomes useful, it becomes heroic, and it becomes the right thing to do. And then if you look at the jurisprudence that's copied there, you will find examples of, let's say, a more aggressive judicial stance. And I think the take-home message is that there is a place for this. So there's a place for going more the South African rule route and being systematic and deferring to governmental bodies. But in cases of crisis, if it's necessary for the judiciary to step in, let's say it breaches formal justice, the justice of the system gets breached, but it addresses material justice, which means that it does something immediately for the human needs that are present. Okay, so that's for an overview on the history and the functionings of social rights. This is a very big topic. I have only covered the basic surface of it, but this should be enough to get you started if you want to look more into it.